We went over a number of objections, and I made some rulings. So let's start with the defendant's objections to some of the exhibits that the state wanted to put in. Mr. Ng, did you want to address that?
Thank you, Your Honor. Mr. Gray and I had a chance to go over almost 400 exhibits over the weekend, and we raised objections to several of them for the court's review. I understand the court is making a ruling that some of the exhibits are admissible and some may not be, but we did make an objection to exhibits 3 and 4, 239, 240, 241, which are Spark of Life exhibits. We object to A, the Spark of Life testimony. We understand the case law, but we respectfully disagree with the Supreme Court's case law on that. Already only one photograph is necessary, and that's why we objected to those. We also objected to...
Okay, let me put on the record what my ruling was on that. The state wanted to put in 5 Spark of Life photographs. Minnesota law, of course, allows for that. I decided that the state could put in 3 of them, not the 5.
We also made several objections, Your Honor, to the autopsy photographs and photographs of Mr. Wright's body at the scene. Those would be 41, 113, 120, 125, 175. It's argued that the photographs of a naked body of Mr. Wright were unnecessary to prove that he was shot by a pistol, where some of the photographs with his eyes open are prejudicial and not terribly probative of the issue, which was his cause of death, which we're not disputing that it was caused by a gunshot wound. And we therefore objected to those exhibits.
Would the state like to put its position on the record?
Thank you, Your Honor. We understood the objections to be about certain photographs with the eyes being open. That is a condition of a dead body on occasion. The autopsy, of course, is very relevant to the issues in the case and all of the injuries, and it is simply a photograph of the accurate condition of the body at the time and necessary for the medical examiner's testimony about the cause of death. We therefore believe that the photographs are relevant and necessary, and we opposed on that basis.
All right, I overruled the defense objections to the autopsy photographs. It's necessary for purposes of describing the injuries. Mr. Ng?
We had another issue that I'd like to put on the record, Your Honor. The passenger of Mr. Wright will be testifying today. And the defense seeks to admit exhibit labeled 1004, which is a packet of Xanax tablets. And the purpose of our admissibility, or the reason for the admissibility of the evidence, is that what happened here is that during the stop, Mr. Wright handed the package of Xanax tablets to his passenger and told her to hide the tablets. She then hid the tablets in her perineum. She was taken to the hospital, and at the hospital, a detective from Brooklyn Center was made to sit with her, which is customary, and during her conversation with the passenger, she told the detective, Mona Pearson, that Mr. Wright had given her the pills and that she hid the pills. We believe this evidence is relevant to show Mr. Wright's consciousness. I mean, is that term we're bandying about in the case, that he was about to flee, that he knew he had an arrest warrant, didn't want the pills to be found on him because once he was in the jail, they would be discovered. We believe this is probative evidence, and it is consistent with our cross-examination of the passenger. We also believe that her statements, the passenger statements, are against her own penal interest because these are Xanax tablets that are not prescribed to anybody and she should not have had. And therefore, when she confessed to Mona Pearson, she was confessing against her own interest. So for all those reasons, we sought to introduce the evidence of this green photograph and also to cross-examine the passenger accordingly.
Would the state like to be heard on its position?
I do, Your Honor. Thank you. It's our position, well, first of all, that the exhibit marked 1004, if the court wants to receive that in the court file only to preserve for the record, should it become an issue on appeal, should not be filed as a public document because it is not an exhibit in the trial. It's just for the appellate record. Secondly, Your Honor, the issue in this case, as you know, concerns the state of mind of Officer Potter when these acts were committed. This court has already ruled that evidence of drugs that were not known to Officer Potter is not admissible, relevant, and certainly prejudicial. And that's exactly what this photograph and this line of inquiry is intended to do, is backdoor that through, to impugn Mr. Wright based on this sort of backdoor approach, and that's why it's being brought out now as well, I believe. So we asked the court to follow its previous ruling and its order of October 27, that this evidence is not relevant and is highly prejudicial and likely to mislead and confuse the jury. It simply has no relevance to Ms. Potter's actions. Any claim that it has some relevance to Mr. Wright's actions is technically, I think, irrelevant. His actions are caught on camera, and Officer Potter will presumably testify about why she did what she did, but certainly there's evidence of what happened. And so it's relevant for that issue, for that reason as well. So we understand the court is, well, I guess I'll just say we, on those bases, objected to it.
Okay. Yes, I rule that would not be admitted as evidence. We'll make it a court exhibit should the case be appealed. I previously ruled that any type of evidence with respect to bad behavior on the part of Mr. Wright would not be admissible unless Officer Potter was aware of it at the time of the incident. The key issue in this case was Ms. Potter's state of mind when this happened, and that the Xanax has nothing to do with that issue and would only serve to mislead or confuse the jury. Okay, were there others?
No, Your Honor, but to preserve the record, we will offer as a court exhibit 1004, and we also offer from yesterday court exhibit 1005, which is a photograph of Daunte Wright pointing a gun into a mirror. The court has ruled that we can't admit those. How would the court prefer that we file these? Would you prefer we file these under seal or provide them to you?
We'll make them a court exhibit, and you can provide them to Mr. Kramer.
Thank you.
Okay, were there other ones, Mr. Ng?
No, Your Honor.
Okay.
Your Honor,
Yes.
if I may briefly, with respect to the exhibit that has now been identified as Court Exhibit 1005, that was from our discussion, I believe, on Monday about an area of cross-examination that the defense wanted to go into, and the court had made a ruling at that time that that photograph would not be allowed. I can't remember if we made a record about this on Monday, but that's what the Court Exhibit 1005 is. And again, I would ask that that not be filed publicly, but made part of the court file for appellate review.
Right, we dealt with that yesterday, actually, but did not make a record of it. So that will not be admitted, but will be a court exhibit. Okay, anything further from the defense?
No, Your Honor.
Okay, is there anything from the state?
Your Honor, we did also deal with objections to Exhibits 29, 30, and 31, defense objections, and we would, I guess just while we're making these records, we might as well that those are, well, 29 is a short video of the passenger, and the other two are photographs of her injuries. The defense did object to those, and the court overruled the objections.
Yes, I'm going to allow the video of the passenger and the video showing her injuries, or the photograph. Okay.
Excuse me, Your Honor.
Yes.
With respect to our, the state's objections to our exhibits, we also have the right under the Sixth Amendment to present a defense. I want to raise that as an issue for appeal if we go there.
Okay.
So we're being denied by the not being able to use these exhibits to present a defense under the Sixth Amendment to the United States Constitution. Thank you.
And, Your Honor, it's well-known case law that while a defendant has a Sixth Amendment right to defend himself, they have to do so within the rules of evidence that this court and courts adopt. So it's not a free-form right, but I understand the counsel's preserving that for the record. But that's the full story.
Okay. Is there anything further that we need to deal with before we get the jury in here?
Your Honor, we did raise two matters in chambers, and I would like to make a quick record of it if I could.
Sure.
So we had raised a concern that counsel might represent to the jury that if, that the state has to prove Ms. Potter did not, too many double negatives, that the state has to prove Ms. Potter knew she had a handgun in her hand. And if the state can prove that, she is not guilty. We think that's a misstatement of the law, and therefore saying that to the jury would be a misstatement of law to them, inconsistent with the court's own instructions. And we brought that up ahead of time because we didn't want to interrupt for the first time bringing it to the court for an objection. And our understanding of the court's position on this is that the defense can argue that as a theory, as a factual theory, but we will take issue and argue to the jury that that is an incorrect, if it's stated in those absolute terms, that we will dispute that with the jury and, of course, direct them to the court's instructions, which will be an accurate statement of the law. I don't know if you want me to move on to the next one or...
Okay. I had ruled that the defense is entitled to argue its theory of the case. And the state and the defense both have conflicting views of what their theories are, but I'm not going to constrain the defense from making their arguments. And they, in fact, do have an expert that's going to talk about slip and capture. So, and I've previously ruled that that expert testimony is admissible. Okay, anything further? All right. Yes?
We did talk about also the attempts by the defense to offer expert opinions, or what amounted to expert opinions, on the reasonable use of force through fact witnesses. Our understanding of the court's ruling is that the court will allow some inquiry about officers' opinions about whether their training would have allowed them to do what Ms. Potter did, I guess. So we're still, we still take objection to that, Your Honor, as both unqualified and unnoticed expert opinion.
Okay, the officers that will be testifying can testify that they were trained on the use of tasers. They can talk about their training. They are officers and they know about that area, and so I'm not going to preclude them from making those statements when they testify. Okay, anything further from the state?
No, Your Honor, thank you.
Anything further from the defense? Okay. Is counsel ready for the jury?
Your Honor, we would request a short recess.
Oh, okay. How short a recess?
We just need to set up, Your Honor.
Okay. Why don't we take like 5 minutes? Would that be enough? Okay, we'll take 5.